My name is Carter White, and along with Stuart Katz, we represent the plaintiff and appellant Kennard Thomas. I'd like to reserve 3 minutes for rebuttal.
Okay.
So this case, I'm going to pick up on Judge Clifton's comment from the last case, turns on the perception of risk. The most important gram factor is whether the plaintiff posed an immediate threat to the officer's safety. Here, the district court found that there was a dispute as to whether Russell's conduct, the officer, was reasonable or unreasonable. And the court actually held that the first prong of qualified immunity was met, and the defendant doesn't contest that. Curiously, right after the court makes that finding on ER 9, at ER 10, it says, nothing's going to change my mind that there aren't genuine issues of material facts. And then makes the statement that really what the genuine issues are what inferences should be drawn. But as the Supreme Court teaches in Tolan v. Cotton, inferences must be drawn in the non-movement's favor. And that's what the district court, that's how the district court got it wrong. And it's really just the same mistake that the Fifth Circuit made, that the Supreme Court corrected in Tolan v. Cotton, that the district court made here. The court took the inferences and the facts in the light not favorable to Thomas, the plaintiff. And if you examine under the proper standard, there's simply just a basic factual dispute over whether the officer's claimed perception of a threat was reasonable or unreasonable. And summary judgment should not have been granted on qualified immunity. The issue about whether it was reasonable for Officer Russell to believe that Thomas was even armed, he concedes he didn't see. And it's a jury could believe that the officer's not telling the truth, that he couldn't or didn't see the plaintiff's hands. It's uncontroverted that the plaintiff came out, stepped out of the closet slowly with his hands up, palms out, facing the officer. And the sergeant, then Officer Rowe, Sergeant Rowe testified that the complainant, Ms. Drayton, thought she might have seen a weapon or stated he's been known to carry a weapon. And Sergeant Rowe's impression that was shared by all the officers, including Russell, prior to going into this house, the squat house, was, I don't think she actually saw anything. And it was unlikely that Drayton had actually seen a firearm. And no officer disagreed with that assessment in the pre-entry meeting.
Is your argument about the hands by his head that it doesn't even really matter if there was a weapon somewhere because you could see his hands and he wasn't holding one? Or are you trying to rely on the idea that there wasn't a weapon anywhere?
If it's clearly established in this court that if someone's holding a weapon and not pointing it at an officer or anyone else, and it's not okay to shoot, then yes, that would be our position. But here it's even more, it's worse because the jury could, it's undisputed that all that Mr. Thomas had in his hand was a small green Bic lighter, which could not have been mistaken for a weapon. He made no furtive moves or shooter stance as was claimed in Longoria. There's claims throughout the defendant's brief that there's somehow some furtive gesture, but when you read the record carefully, the officer's statement right after, they tried to get him to say that Thomas lunged, and he says no. He just walked out of the. He was walking out, and the officer said he felt afraid because he was surprised. But it's unreasonable to be surprised when he apparently knew someone was in there. He claimed that he was opening the door. Thomas says he didn't do that. He had time to step back away. He was 2 or 3 feet away when he shot him. And so what's unreasonable, or what a jury could find, is that this gentleman actually could see Thomas's hands. And that there's another, it's not just, spin or inferences, as the district court talked about. There's a real serious dispute here about the lighting. Thomas testified in his deposition that when he was in the closet, he could see the light that came in from the blinds. This is 7 p.m. on a June night in Sacramento, and it's light outside, and there's light coming in, and Thomas said he could see all the way across that room. And the officer, while claiming he didn't or couldn't see the hands, was using his flashlight on his handgun. And so it's reasonable for a jury to find that there was sufficient lighting for him to see that. And the officers never claimed that he saw any weapon. And so the undisputed facts are that Thomas was unarmed. There's no claim that anyone saw a weapon or any mistake of fact that there could have been a weapon. He was not resisting arrest. He was suspected at most of misdemeanor trespass. They weren't there to arrest him at all.
At some level, he was resisting in the sense of he didn't respond when the law enforcement officers first appeared. He may have been the person they saw dashing, and he was hiding in a closet. So it's not like he was making himself readily available. He was. It felt like a kid's game of hide and seek, in the sense that I can recall my brother hiding in the closet and then jumping out trying to scare me, and I was 8, and that's different. But I'm not sure it's quite as undisputed as you suggested that he posed no risk.
Well,
or more importantly, that the officer couldn't have perceived reasonably that he posed a risk.
But there's nothing. So this is in the sample case, the Sixth Circuit case that we cite, where the court found this was within the obvious. They had seen the burglary suspect, and the burglary suspect fled and hid in a cabinet, and he was shot. And so it's not reasonable to perceive this. We have expert testimony in the record that this was not a reasonable perception by the officer, and it's exactly what he expected.
Part of what makes this so difficult for us, and we have a lot of these cases, is that with regard to qualified immunity, the Supreme Court has said in pretty plain terms that it protects all but the plainly incompetent or those who knowingly violate the law. And I've seen no suggestion here that there's anything to support the proposition that the officer had it out for this particular suspect or person he was seeking out. So I think we're focused on how much slack does the officer get cut, and if the Supreme Court says, well, you got to be plainly incompetent not to get qualified immunity, what here makes it to that plainly incompetent standard?
Your Honor, if this shooting is allowed to stand, an officer can shoot anybody at any time. It is plain incompetence when there's no weapon seen. They expect that the person comes out. From viewing the testimony in the light most favorable to Thomas, the gentleman is slowly emerging from the closet. It is not reasonable for this officer to have perceived a threat of immediate or otherwise harm. And, the Supreme Court, the case law doesn't require malice or any bad feelings about this. And Russell himself testified he didn't even know who he had shot. He didn't know if it was Thomas or not. And so I would ask the court to, for qualified immunity purposes, I think the district court was wrong here in trying to find a case of factual identity, factually identical. And, the court seemed to resist the general proposition from Tennessee v. Garner, but this court's precedent on second prong of qualified immunity holds that if there is a consensus of cases from other circuits or this circuit, and there is a consensus here that you can't shoot an unarmed person who is surrendering, who poses no immediate threat. And this officer's perception of the threat was not reasonable. If there are no further questions, I'd like to reserve the remainder of my time for rebuttal, please.
Very well. Hear from the government. Go ahead.
Good morning, Your Honors. My name is Carl Fessenden from the Law Office of Porter Scott. I represent the appellees in this case. As you just heard, the appellant's argument is that Mr. Thomas did not present an imminent or immediate threat, and therefore deadly force was not justified. But the error in their analysis is exactly what this court and the Supreme Court has said you cannot do, especially in the Fourth Amendment context. That is, focus on some facts, be very general, and ignore the other facts. And that's what they're doing here, and that's precluded. The question for this court is whether under all the circumstances that were presented, was there clearly established law that would have informed every reasonable officer, and as this court just pointed out, that means all but the plainly incompetent, that Thomas was not an imminent threat or immediate threat.
So if we
when
take
he stepped out of that closet unannounced within 2 or 3 feet.
So if we take plaintiff's version of the facts, the officers said, come out of the closet. He slowly then comes out of the closet, obeying their commands with his hands up, empty other than a lighter that's green, in a lit room. On that set of facts, taking plaintiff's version, you're saying it's okay to shoot?
Yes, Your Honor, but those aren't the facts.
Okay, so what am I missing?
So Officer or Deputy Russell, the announcements are not what the plaintiff suggests. All they said
Let me
was,
stop you right there.
Let
me stop you right there.
Sure.
You say not what the plaintiff suggests. We have to be careful here not to try to resolve potential factual disputes. So I want you to distinguish between plaintiff's argument and what evidence there may be in the record to support a conclusion of facts contrary to what you're suggesting was the case.
Thank you, Your Honor. I was trying to be polite, I suppose, but they misrepresent the facts.
To the extent
Well, then let me say, your brief says that Thomas quickly, unexpectedly, and furtively emerged from a dark closet. And I got to say, looking at the record, I'm not sure that's not genuinely disputed.
Well, no, Your Honor, as the court pointed out, there is no dispute. He took the facts as to the best benefit to the plaintiff. So that's how he took them.
Well, but the plaintiff...
And he made the decision. And the decision that he made was that, hey, you're right. He was stepped out. But the very important fact is they're looking for a violent guy who hid from them, who concealed himself, and then steps out of a closet without any warning whatsoever. None. And he's within 2 or 3 feet when this happens. And so the question for this court, as I point out, is whether, is there any case that would tell this officer under these facts that that didn't pose an imminent threat of harm to him, even if his hands were up? And the court accepted, and we put it in our own brief, or when we moved for summary judgment, we put the facts in there that he says his hands are up. And the court has to accept that as true, that his hands are up.
So why doesn't the court also have to accept his testimony that he came out of the closet slowly?
Correct. And exact. But he did so unexpectedly.
Well, how is it unexpected when the officers just told him to come out of the closet?
That's not what the officers said. The officers just made general announcements. Sheriff's Department, make yourself known. The undisputed evidence, and nobody can dispute this, is that the officers didn't know whether there was or was not somebody in that closet. They were clearing the room.
So at ER 49, 15 to 19, the question is, okay, so you gave him commands to come out of the closet, correct? Answer, yes, as we were searching the house.
And you have to read the actual testimony. He did make, yes, they were telling people to make themselves known. So if he was in the closet, he was telling them to closet out of closet. But the evidence is he didn't know whether there was a person in that closet or not. He was just saying,
he testified himself, Officer Russell testified himself. He went up to the closet door. He doesn't recall what direction, but he did slide the door either to the left or the right, and Thomas comes into view.
Right.
Now, what exactly would you expect Thomas to do at that point? He has just been discovered. If he lunged at the officer, that may be one thing, but there's no testimony like that. Suddenly, the officer sees Thomas is there, not an enormous surprise, because he was looking for Thomas and thinking that he might be there. That's what he slid the door. So how does that translate into a conclusion that Thomas furtively and suddenly and quickly emerged from the closet?
So those are, well,
those are adjectives you used.
The question is, oh, sorry, Your Honor.
Oh. I mean, your brief used those, I guess they're adverbs in that case, but I don't see where the testimony of Officer Russell supports those factual assertions. And that gets to the problem that I have, which is that if to make your case you have to polish up the facts a little bit, how is this not appropriate for something to be resolved by a jury?
I don't have to polish up the facts at all. He hid from these officers. He did not make any announcement at all before he came out of that closet.
Why is that? I'm sorry, counsel. Why is that important if the officers tell him to come out of the closet?
Again, Your Honor, that's not the testimony.
No, I'm looking at 49, as Judge Friedland did. So you gave him commands to come out of the closet, correct? And his answer is yes, as we were searching the house.
But if you read the actual deposition testimony,
I've got it right
Russell,
here.
No, if the deposition testimony says we made announcements, Sheriff's Department, make yourself known, not that come out of the closet. He was just acknowledging. They just took one section of his deposition. We put in the deposition that shows the context of the warrant, which was.
What's your best case that says that a person has to announce their presence if they're surrendering?
So, Your Honor, if to answer that question, you're turning the clearly established on its head.
No, I'm just saying, if we've got a case, give it to me.
Well, I don't think there's any case.
What you've been saying is the fact that he didn't announce is conclusive. What case says that?
Oh, I don't think there is any, Your Honor. But again, you're shifting the burden to me, and the burden is not the appellees in this case. The burden is on the plaintiff to show that clearly established law would show under these facts that that everybody except for the most incompetent would understand that it wasn't an imminent threat of harm. So you have a person who's hiding from you, who is violent, who ran apparently from you and isn't making themselves known. And as soon as you get within 2 or 3 feet, he steps out of the closet. So he is coming towards you. And the officer has to make a decision at that very moment. Do I shoot or do I do something else? And he made the decision to shoot, obviously. And the question is there any law that would tell him and every reasonable officer, and that's the standard, every reasonable officer, that in that circumstance, what he did was unlawful? I agree. We could get into a debate about whether there's a Fourth Amendment violation, just like the court pointed out, but that's not the issue here. The issue is a legal one, which is.
Wouldn't you agree, as a matter of general proposition, that if a person is surrendering with their hands up and no weapon, and the officer precedes them, it's clearly established that the officer doesn't have a constitutional right to shoot them?
As a general proposition, I agree with you.
And but basically, that's what they're claiming under these set of facts. And I know you disagree with the facts, and no question about it. But I mean, we have to take the facts in the light most favorable to the plaintiff.
Correct.
And it seems to me that what your argument boils down to is a disagreement about what happened when he came out of the closet. The officers say he came out in a threatening manner. You said furtively and unexpectedly. He says no. I mean, that seems to me the essence of the factual dispute here.
Your Honor,
am I wrong?
Yeah, because we don't dispute that. In our summary judgment motion, we put in his testimony about what happened, and we asked the court, assume that is correct. Assume that is correct. Yeah. And what do you find here? Well, again, it's really important that we understand the context of this event. It's not just that he is unarmed and coming out of the closet, because they put a lot of focus on this notion that he's just surrendering. Well, that would require an officer to get into somebody's brain and understand the intention. That's not what we do here.
Well, can't a jury think that having your hands up is a sign of surrender? I mean, maybe you can argue it's not, but isn't that a reasonable inference that a jury might draw?
It could be, Your Honor. It's a reasonable inference when you're assessing the Fourth Amendment and whether there's a violation. But the question for here is, under these circumstances, when this person comes out without warning, stepping towards the officer, hands up, the officer has to make a decision right then what to do. Those hands up could be, I'm 2 feet from you. I'm going to grab your gun very easily. So is he surrendering? I don't know if he is or not, but that's not the legal question for this court. The legal question is, was there any law understanding all the facts and who this person was that would have told this officer that every single reasonable officer would have known that you can't shoot in that context? And there isn't any. And I think
you're asking us to transfer the factual uncertainty to a qualified immunity standard. We're not looking for a case that says this collection of facts leads to a conclusion as a matter of law that this is what happened. We are instructed to accept plaintiff's proposition. In this case, plaintiff's proposition is that a jury, the finder of fact, could conclude that even though the officer may have perceived a threat, that conclusion wasn't reasonable because, in fact, Thomas did not pose a threat. And then we get to the legal question that we have to resolve, which you responded to Chief Judge Thomas's inquiry a few moments ago. If somebody is coming out with the hands up without a weapon, is the law established that the officer can't simply shoot him because of whatever fear the officer might have? So I think we have to try to separate the facts and law, and I'm not sure that what you're telling us accepts that proposition and does, in fact, accept that the finder of fact could find a different set of facts than you've portrayed.
Well, it's not what I'm portraying, Your Honor. I mean, we put in our brief, he came out of the closet as he described.
Well, you put in your brief that he came out quickly, unexpectedly, and furtively, and I don't find that to be true as a matter of law, based on the record in front of us.
That is the perception of the officer.
But that's a different question. That is a different question.
Yeah, I agree.
You have to accept the facts as portrayed by plaintiff for purposes of summary judgment.
And I agree with you. And that's what the court did. That's what the district court did. He accepted as true plaintiff's statements as to the facts, because what the court is focusing in on is what the Ninth Circuit and the Supreme Court have said repeatedly. You cannot just have general statements. So I agree with you. If the facts were only that he came out of the closet with his hands up, stepping towards him, if those were the only facts, I agree with you. You can't shoot him. The law is obvious there. But that's not this fact. That's not this case.
Yeah, but then it gets down to how he emerged from the closet. And he says he came slowly with his hands up. Your officers say he came in a threatening manner. And that's a factual dispute. There are two different results depending on how you resolve those facts.
Again, I think the court is falling into the same trap here, which is conflating the arguments. Whether he perceived it that way goes to the reasonableness of his conduct. In this case, the court accepts as true the plaintiff's version, and that's what the district court said. He came out of the closet with his hands up and stepped out one step, 2 to 3 feet without any warning, without any acknowledgement. And there is no case that would suggest even remotely that in that circumstance, the person didn't
why
create
doesn't AKH speak to this? So AKH is about when the officers told a suspect to take his hands out of his pockets, and when he did obey them, then the officers shot. And our court said, if you tell someone to do something, you can't say it's threatening when they obey. Why doesn't that speak directly to this, asking him to leave the closet and then having him leave the closet?
Well, again, he made a statement of make yourself known.
Well, but you keep saying that, but your client testified that he told him to leave the closet. So the jury could.
But my client also testified, undisputed, he had no idea whether somebody was in the closet or not. They were just trying to find a person, so they didn't know.
Like in that case, though, for example, the officer had no way of knowing whether, when he said take your hand out of your pocket, he had no way of knowing whether he had a weapon in it or not. It's a stronger case, actually, than this one.
There was a specific dispute of fact between the other officers and the plaintiff about whether they even said something like stop and drop it or something like that. There was a factual dispute in that case that doesn't exist here. And can I know I'm out of time, just really briefly. I would like just to point out to the court the recent decision of the Ninth Circuit in O'Dane, where the court very clearly said obviousness is not something that should typically be applied in Fourth Amendment cases because it is so fact specific, and that you cannot ignore all the facts. And even if you accept, Your Honors, as true, which the court below did, that he came out one step hands up, you still got to understand that he's a violent guy who might have a gun, might have a knife, who did it unexpectedly, and the officer was forced to make a split-second decision. What case would tell that officer that that's unconstitutional? There is none. Thank you, Your Honor. I appreciate it.
We'll hear rebuttal.
Thank you, Your Honor. I think the conflation here is that the defendant wants the totality of the circumstances test, which is appropriate in a Fourth Amendment analysis, to apply to include their version of the facts. And what's supposed to be done here is applying as the Supreme Court did in Tolan, in even a second-pronged qualified immunity case, that the inferences and facts have to be drawn in the favor of Thomas. Totality of the circumstances does not mean take the facts in the light most favorable to the officer. I want to make one point about this circumstance of Thomas supposedly being dangerous or violent. There's a pretty serious discrepancy or discrepancies in Deputy Russell's declaration in this case, in his statement. If you compare ER 172, where he says, well, we did a criminal records check, but we didn't really delve into his criminal history. We just found that he was a probationer. And that's actually contra what is in his declaration, where he says they knew about all these other arrests or charges of interfering with officers or somehow violence. They knew they were there. They didn't have an arrest warrant. They were just there to serve this gentleman with a
restraining order about violence, and they had information, correct or not, we don't know at this point, that he might have a weapon and he might be violent, right?
And
he was trespassing in a house.
Right.
Misdemeanor, I concede, but he was trespassing. So.
Right. And we do not contest that he did not have a right to be in that house.
And you would agree, of course, that although there's a dispute as to maybe how much light there was, it was 7 o'clock at night, there were darkened portions, he's hiding, they don't know where he is, right?
Well, he is hiding, but the officer, by his testimony, is that he's holding his revolver in one hand and opening the closet door with the left. Thomas says that didn't happen. Thomas says he just came out of there without the door being opened. But the testimony is he fell back in the closet. He didn't come 2 or 3 feet out of the closet. He barely took one step. 1 foot was still in the closet, and he really never came out. Then the officer was increasing the distance. in the Graham factors on the issue of warning, the factor is whether it was practical for the officers to give warning. As the court has noted, there's no case that says Mr. Thomas has to announce himself or somehow give the officer a warning of, I'm coming out. It was not a reasonable perception. I want to close with this quote from Dorley v. Rutherford at 272 F. 3rd at 1285. Every police officer, and this is clearly established law from this Ninth Circuit in 2001, every police officer should know that it is objectively unreasonable to shoot, even with lead shot wrapped in a cloth case, an unarmed man who has committed no serious offense, has been given no warning of the imminent use of such a significant degree of force, poses no risk of flight, presents no objectively reasonable threat to the safety of the officer or other individuals. That's clearly established in this court and in the consensus of all the courts. We ask this court to reverse and remand this case to the district court and reverse the qualified immunity decision.
Thank you both for your arguments this morning. The case just argued will be submitted for decision.